real disease, but was never taken to an emergency room or given IV. That infant received medical care, and the department ceased holding any families at the facility after our review. Congress established the Officer for Civil Rights and Civil Liberties as part of DHS when it enacted the Homeland Security Act of 2002. The officer is charged with ensuring that the department complies with constitutional, statutory, regulatory, policy, and other requirements relating to the civil rights and civil liberties of individuals affected by the programs and activities of the department. This and all other statutory work appeared to stop on March 21st, 2025, after DHS officials informed me and my colleagues that our positions at CRCL were being eliminated. On that same day, a spokesperson for the department issued a statement saying CRCL and the other oversight offices obstructed immigration enforcement by adding bureaucratic hurdles and undermining the mission of DHS. CRCL was and is crucial to the department's mission. In our work, we have sought to minimize the department's risk of violating the Constitution, and we have collaborated with departmental components, making recommendations to make operations safer, more efficient, and respectful of individual rights. The department's actions on March 21st resulted in the office ceasing to investigate more than 500 open complaint investigations. These include, for example, complaints about sexual abuse and deaths in custody. Other CRCL responsibilities and functions were halted on that day, such as EEO responsibilities, implementation of the Violence Against Women Act, and oversight of ICE's 287G program. Required reports to Congress are pending. If CRCL were operating as it should now, it likely would have received and sought to address allegations about the kind of conduct that had prompted the hearing this afternoon. After the filing of a lawsuit challenging the elimination of CRCL and the two other oversight offices, a department official testified in that case that CRCL would be reconstituted. Asked by the judge if there was a plan for this, the department official said he had a notion of a plan. The department official subsequently provided a declaration to the court in which he stated that CRCL would consist of 22 employees and some contractual support. The concerning activities described, Ms. Ximena has described today, and others that you will hear, I think explain that oversight is needed more now than ever. I'm deeply concerned that without a functioning CRCL, the guardrails that Congress established to ensure that DHS abides by the Constitution will be removed. We urge Congress to investigate the department's decision regarding CRCL and how the office's statutory mission to protect constitutional rights will be carried out. Thank you.
Thank you very much, Ms. Tosado. Ms. Smith?
My name is Laura Smith, and I'm the Executive Director of the Children's Legal Center, an organization providing immigration legal services to children and families. I'm testifying today to tell the story of Mr. F., a father of 3 children and a Venezuelan that the U.S. government has been holding in detention despite a court order calling for his release on bond. Mr. F. entered the United States after being fingerprinted and background checked by immigration authorities. He was granted permission to enter the U.S. He followed the law. He applied for a TPS and asylum. He's simply a father who loves and strives to care for his young children. He has no criminal history, has done nothing wrong, and yet he is now faced with 2 horrifying options: either to disappear into a prison in El Salvador where he will never see his children again, or stay indefinitely in a prison here in the US with no foreseeable release date. Let me tell you his story. My organization was assigned to provide legal services to 2 young children, ages 10 and 12 years old, who were released from or our custody to their father, Mr. F. On March 21st, ICE arrived at their home in Illinois, seemingly to be performing a wellness check on Mr. F's 2 children. During this wellness check, they arrested and detained Mr. F in front of his children. The reason for Mr. F's arrest was unknown, but based on the information I have available to me today, the visit was not to ensure the wellness of his children. The children called our office terrified and confused. These young children had no idea why their father was just arrested and taken away from them. I do not know exactly why Mr. F was arrested. However, after his arrest, DHS took a picture of Mr. F and posted it on social media, claiming to have arrested a member of Tren de Aragua. Mr. F also learned that his bank accounts, which contained money to care for his minor children, were frozen. Mr. F was taken to a detention center in Wisconsin. Our office sent documents for our client to sign, documents ICE requires to confirm our representation in their system. Before we even received the documents back, we learned that he had been moved from Wisconsin to Illinois and then to Texas. We feared that he was being taken to Seca in El Salvador and that his children would never see him again. We quickly filed a petition for a writ of habeas corpus and asked for an emergency temporary order to prevent Mr. F's removal from the United States. The federal court quickly granted our request and also ordered the U.S. government to provide Mr. F and his counsel, me, with notice of any Alien Enemies Act designation. To this day, the U.S. government has not provided me with any notice. While all of this was occurring, DHS initiated a case in the immigration court to remove Mr. F from the United States. We've had multiple hearings in which the detention center did not allow Mr. F to even appear in his own case. DHS never alleged in court that Mr. F is a member of any gang or committed any crime. In fact, the immigration court ordered that ICE release Mr. F on bond, finding that he is not a danger to the community. The next day, a U.S. citizen and family friend posted the bond for Mr. F for the ICE to release him on bond. ICE denied the posting of the bond. The U.S. citizen then posted the bond again with a better picture of her passport. ICE denied the posting of the bond again, claiming that Mr. F cannot be released on bond despite the immigration judge's order to do so. Later, the family hired a local bonds attorney who regularly posts bond at the Bluebonnet Detention Center where Mr. F is located. ICE also denied this posting of the bond and for the first time cited national security reasons. I then flew to Texas to visit Mr. F at the Bluebonnet Detention Center. During this meeting, for the first time, Mr. F shared a single piece of paper with me stating that he was being designated a member of Tren de Aragua and was being removed under the Alien Enemies Act. ICE and counsel for the U.S. government had never given me this paper in response to my requests or even during any of Mr. F's immigration court proceedings, despite having been ordered to do so by the federal court. Although I am listed as his attorney of record, they did not allow him to share the paper with me until I visited a month later. The notice contains no factual allegations to even understand why the U.S. government has detained him and determined that he is a member of Tren de Aragua. I struggled to explain to Mr. F why he was arrested in front of his children, detained in a prison for over 2 months, and falsely accused of being a member of Tren de Aragua without any notice as to why he was being considered a gang member or any opportunity to respond to the accusations. Recently, I met with Mr. F's 2 children, ages 10 and 12. I also had the unfortunate job of explaining to them that their father may be transferred to Seca in El Salvador, despite having done nothing wrong. I used colored markers on a whiteboard to explain to these young children where our government's laws have failed their family and that these 2 children may never see their father again. I am a U.S. citizen and I am scared. Due process prevents the government from arresting us for no reason and putting us in prison indefinitely. If the government is not following the law and is violating people's constitutional rights, then we are all in danger of suffering the same fate as Mr. F.
Thank you, Ms. Smith. Ms. Brane.
Yes. Thank you for the opportunity to speak to you all today. My name is Michelle Brane. I'm the Executive Director of Together and Free. Before this role, I served as the Immigration Detention Ombudsman, and before that, as the head of the Family Reunification Task Force at the Department of Homeland Security. We're currently seeing a dramatic increase in immigration enforcement and detention without adequate oversight. And this is leading to the denial of due process, harm to families, and real tangible risks to our communities. Congress established the Office of the Immigration Detention Ombudsman in 2019 to independently examine detention conditions and promote humane treatment. We worked directly with ICE, CBP, detainees, and families to find practical solutions that make sense for all parties involved. Our team of over 100 staff visited any detention facility with more than 50 detainees on a weekly basis, and we resolved more than 11,000 complaints in 2024 alone. But on March 21st, 2025, DHS shut down OIDO and fired all its employees without warning. Overnight, case managers stopped visiting facilities, complaints were no longer answered, inspections went unfinished, and unresolved issues were left behind. DHS later claimed that a team of just 5 to 7 staff could replace the work of these over 100 staff. This is simply not credible. OIDO's presence wasn't just about paperwork, it was about people. And our work made immigration detention not only more humane, but also more efficient and better for detainees, staff, contractors, ICE staff, and our country. Our team resolved issues of insufficient food, helped people in detention access medical care, addressed staffing issues, leaky roofs, and mold. We saw problems early, de-escalated conflicts, and helped avoid litigation. Eliminating OIDO has removed this critical layer of accountability. We've already seen the consequences. Already, since February of this year, we have seen 9 deaths in ICE custody at least. Meanwhile, DHS is expanding detention, turning to military bases and foreign prisons. And even members of Congress are being blocked from conducting oversight. But it has not stopped there. On March 15th, over 235 men disappeared from the United States into Sabotage, a notorious prison in El Salvador, at the hands of DHS. President Bukele himself has said the only way out is in a body bag. Together and Free is in contact with the families of 130 of these men. They began reaching out to us on March 16th after seeing videos mocking the suffering of their loved ones posted by President Bukele and Secretary of State Marco Rubio. The U.S. publicly labeled these men as members of the Venezuelan gang Tren de Aragua, but has presented no evidence, as you heard, and provided no chance for defense. Most of the men were mid-asylum proceedings and were deported before their court dates. The U.S. government admits that most have had no criminal record. Some appear to be identified solely based on tattoos that you might find on any young man walking the streets of this country. A crown, a child's name, a date of birth, or even a Barcelona soccer logo. I spoke with a mother whose sons, aged 18 and 20, were detained by ICE on their way to help do hair and makeup for a friend's music video. Another mother told me that her son was detained while riding his brand new bicycle for the first and maybe only time. Many had followed the rules. They had TPS or work authorization and were detained when they went to an ICE check-in. It has now been 88 days. Many Americans may have moved on from this event because so many things are happening. But these families think about their sons, partners, fathers, or brothers every day and hope and pray that they are still alive. The government has not provided an official accounting of who was disappeared to Sabotage. And this to me feels very similar to the family separation that I experienced and observed under the first Trump administration, where the administration did not keep track of the families that they tore apart. I worry that these families will never get certainty about their disappeared family members unless we take action. And let me be very clear. DHS could bring every single one of those men back to the United States immediately if they wanted to. Instead, they continue attempts to deport people to other dangerous third countries that are not their own, like Libya and South Sudan. After a court stopped the removal of 8 men to South Sudan, DHS placed them in a shipping container in Djibouti, where they have been held in shackles 24 hours a day for over 2 weeks. They haven't been allowed to speak to their attorneys. And even ICE has complained that the guards that are guarding them are living in dangerous conditions. But this crisis is one of the government's own making. Instead of flying the men back to the United States to provide them with a due process ordered by a court and resolving the issue, DHS has simply rotated staff and left these men detained behind. Why does all of this matter? Because this is a dangerous misuse of the Alien Enemies Act, a concern already raised by multiple courts. Because due process is not optional. Our Constitution guarantees it to everyone on U.S. soil, not just U.S. citizens. Because U.S. taxpayers are funding the detention of people in conditions that violate U.S. laws and values, and the administration is preventing all oversight, including that of U.S. congressmen, and allowing the government to strip legal protections from one group, which means they could do it to any of us. The president has already suggested sending U.S. citizens to Sabotage. This is not hyperbole, and it is not a joke. It is real, and failing to act puts our freedoms and democracy at risk. Thank you.
Thank you very much, Ms. McCord.
Thank you, Senators. Thank you for inviting me today. As you noted, I served decades at the Department of Justice before founding ICAP at Georgetown Law 8 years ago, where we used litigation and policy work to defend constitutional rights and to ensure accountability for our governmental institutions. I'm here today to talk about the Trump administration's multifaceted deportation policy that threatens the fundamental constitutional rights of not just citizens, but non-citizens. Start with the president's use of Title 10, Section 12406 of the United States Code to prospectively federalize the National Guard to protect ICE agents and federal property during First Amendment protected protests anywhere in the country. Saturday's presidential memorandum asserts that protests or acts of violence in response to ICE raids constitute a form of rebellion against the authority of the United States, a prerequisite to federalizing National Guard troops under Section 12406, if they directly inhibit the execution of the laws. Although there could be protest activity directed at the government that becomes so pervasively violent that it might qualify as a rebellion, such as the attack on the United States Capitol on January 6th, 2021, the presidential memorandum does not refer to any particular ongoing protest in any particular location, not even Los Angeles, where the National Guard has now been federalized and deployed, nor does it provide any other support for such a conclusion. Instead, it purports to apply to protests that, quote, are occurring or are likely to occur based on current threat assessments and planned operations, unquote. And it gives the Secretary of the Defense the power to use regular armed forces to augment the National Guard, which the Secretary has now used to send 700 Marines into California. With the total number of federalized National Guard and Marines at 4,700, far outnumbering the most protesters that have been seen at any given protest. This assault on fundamental First Amendment rights of citizens and non-citizens is unprecedented, beyond the authority delegated by Congress and meant to quash protected speech. Next, consider the President's Alien Enemies Act proclamation, used to remove Venezuelan detainees alleged to be members of Tren de Aragua to Seacoast. Setting aside for now whether the Alien Enemies Act can be used in this way, all 9 members of the United States Supreme Court agreed that the detainees are constitutionally entitled to due process of law. That means notice that they are subject to removal under the Act within a reasonable time and in such a manner to allow them to seek judicial review before their removal occurs. The fundamental right to due process protects everyone, not just Venezuelan detainees, before the government deprives someone of life, liberty, or property. The administration's attempt to summarily remove other detainees to Libya and South Sudan, and its mistaken removal of Kilmar Abrego Garcia without due process are additional violations of due process rights. The justifications given that detainees are terrorists or criminals is not an excuse. Indeed, the Fourth Circuit Judge J. Harvey Wilkinson III, writing about Abrego Garcia, cautioned, quote, if today the executive claims the right to deport without due process and in disregard of court orders, what assurance will there be tomorrow that it will not deport American citizens and then disclaim responsibility to bring them home? And this is not all. The administration has attempted to summarily strip foreign students and researchers of their visas for engaging in First Amendment protected activity on university campuses. It has threatened criminal investigations of so-called sanctuary cities that choose as a matter of public safety not to voluntarily cooperate with federal immigration officials beyond what is required by federal law. It has charged a state judge for allegedly obstructing ICE's attempt to arrest an immigrant appearing in her courtroom, and it has charged a U.S. Congress member with assaulting an ICE officer during attempted oversight at a detention center. These actions have consequential impacts on First Amendment rights, as well as principles of federalism, separation of powers, and the rule of law. Finally, no hearing on these topics would be complete without discussing President Trump's executive order purporting to reinterpret the 14th Amendment to deny citizenship to newborn children and list at least one parent as a citizen or a lawful permanent resident, even if both parents are here lawfully but temporarily. Denying citizenship to newborns would irreparably harm not only them and their families, who may face deportations and family separation. It would also impact newborns of U.S. citizens for whom a birth certificate would no longer be sufficient proof of citizenship. Immediate legal challenges, including one brought by my organization, ICAP, resulted in nationwide preliminary injunctions based on the order's blatant violation of the plain text of the 14th Amendment, 125-year-old binding Supreme Court precedent, a congressional statute, and centuries of historical practice. Thank you for the opportunity to testify today.
Thanks, Ms. McCord. Senator from California is recognized.
Thank you, Senator Durbin. I'm going to set the stage for my first question by sharing something that's probably not news to most people that are here in the room, but for the record, there has been an unprecedented number of arrests taking place over the last several weeks at immigration court dates, hearings, and regular check-ins. These arrests are specifically targeting immigrants who are trying to comply with our immigration laws, people who are showing up to have their day in court and present the evidence to a judge. This is the United States justice system, after all, where you get a fair shot to make your case in court. But instead, the Trump administration is sabotaging the right to due process. People who have active cases are having their cases totally dismissed, and when they walk out of that courtroom, ICE agents are waiting to arrest them and thrown into removal proceedings before they could ever make their case before a judge. This should raise alarm for everyone listening. People are being deprived of their day in court. This is no accident. It's a deliberate strategy to wash away the cornerstone of the U.S. Constitution just because due process is inconvenient for Trump's agenda. My question is for Ms. Brunet. How is this abuse of dismissals by ICE different from previous uses of dismissals? And is this a concerning change in practice, and why?
Thank you very much for the question. It is a drastic change from previous practice. So generally speaking, when a case is dismissed, that is seen as a finding that it's not worth pursuing, that the grounds that the government was charging may not be sufficient, or that you're going to provide the person with an opportunity to pursue another avenue. And so I think initially when people were receiving dismissals, there was some confusion or even sense of relief. I'll be able to pursue my asylum claim separately as an affirmative claim, perhaps. But instead, as you noted, people are immediately being arrested upon leaving the courtroom and charged with put through a different process of expedited removal, a faster sort of rocket docket of proceedings that provide less due process for people and don't provide them the opportunity to go through the process they had been prepared for. They're also resulting in these cases in immediate detentions, again, as you noted, upon leaving the courtroom. And many times this is resulting in separation from families, children who are present, and we're expecting to go through a normal process, and so are traumatized by the process.
So what do these actions suggest in terms of President Trump and his administration's respect for due process?
It's disrespect for due process and basically deciding not to follow the procedures that don't fit with their agenda and making up their own.
Thank you. Speaking of due process, when a president ignores court orders, detains people without hearings, and uses made-up emergencies to get around the law, it's not just about immigration enforcement anymore. It raises real concerns about whether the basic constitutional rules that protect all of us are being dismantled. And if President Trump can take those rights from people he views as the most vulnerable or politically unpopular, what's to stop him from coming after anybody else next? Question for Ms. McCord. In your view, how do these due process violations fit into a larger pattern of the administration trying to put itself above the law? And what does that mean for the rights of U.S. citizens going forward?
Well, certainly, I think what we've seen is an escalation in failing to follow the proper due process procedures, oftentimes in the name of national security. I would say hiding behind this guise of national security. Call people terrorists, call them criminals, and maybe Americans won't care. They can be deported without notice. No one is going to call their senators. No one's going to protest because they're terrorists and criminals. But the label terrorists and criminals does not mean a person is a terrorist or a criminal. And that's why judges across the country have found, including our U.S. Supreme Court, that due process is a fundamental right. It's what our system of laws is built on. It's critical to the rule of law. And that's why 9 members of the Supreme Court have agreed that due process must be provided. I fear that this continued failure to follow due process in the name of national security will expand beyond where it has been so far.
Thank you very much. Thank you, Mr. Chair.
Thank you, Senator, for joining us. I know you have to catch a plane for obvious reasons back in the return to California. Thank you for your participation. Ms. Cristobal, what a heartbreaking story you've told us. 2.5 weeks in prison or jail for you. Were there any others in like circumstances that had been arrested by ICE or authorities for immigration issues?
Yes, there was many in the same situation. A lot of them ripped away from the comfort of their own home. A lot of them walking on the side of the street, and a lot of them went to their court date and got ripped away there. So there's a lot of people being taken by ICE.
You were pulled over for a traffic violation.
Yes, I was one that I didn't commit.
Mm-hmm. You came to this country at the age of 4.
Yes, sir.
Do you remember the family discussion about coming to the United States?
No, I don't have any memory before the age of 7 or 8.
That's understandable.
Yeah.
So I look at your situation, and there's only one ray of hope in the whole thing. When you say your community rallied around you, even those who were maybe not politically on your side. Tell us about that.
It enlightened people from my community that this isn't an immigration problem. It's a human rights problem. There was a lot of conservatives who thought they were voting to get criminals out of the country and protect the United States. And whenever they saw that a 19-year-old student, active member of the community, was taken to a detention center, they quickly realized that it wasn't the right thing to do and that it was more a human rights issue rather than an immigration issue.
We hear so much reporting about ICE activities, some reactions, demonstrations, and I hope they're peaceful. But we don't hear enough about what you just told us there. This eye-opening experience where people who thought we were going after murderers and rapists and terrorists and mentally ill people who were going to do us harm, and it turns out they're going after a 19-year-old who likes to do running and is involved in school activities and working toward her degree. That, I think, is an eye-opener for so many people. It doesn't make sense. They wanted the members of the gang taken off the street, and instead they went after you. I'm sorry that you lived through this experience. Ms. Smith, this situation described by Senator Padilla is one that I've heard about in our state of Illinois, where people are responding to the notice of the court to appear. They're complying with what they believe to be the law of the land, show up in court. And if the charges, as Ms. Brane explained, are dismissed against them, it appears that they're arrested on the spot and taken away. Have you seen this yourself?
I've heard reports from my colleagues, yes, in Chicago, that ICE has been in the hallways of the Chicago Immigration Court with a box full of handcuffs, ready to arrest people as they leave their immigration proceedings. And so our clients are calling our office saying, what do I do? Do I go to my master calendar hearing or do I not? Do I follow the law and attend court the way I was planning to? Or if I do that, am I going to be arrested by ICE? And therefore now I'm afraid to follow the law the way I was planning to follow it.
An absolute catch-22. They tell you to go to court, you go to court, they dismiss the claim and arrest you on the spot. Franz Kafka would have a ball with this one. This is so awful, and what a miscarriage of justice that it's been. Ms. McCord, as we look at the options the president has turned to exercise the use of military authority here, what your argument is, we don't have the rebellion, we don't have the invasion, we don't have the statutory basis for the use of this. How and when do you think this will be resolved in court?
Well, we know that the state of California and Governor Newsom has sued the administration for an injunction to stop this unlawful federalization of the National Guard and the use of the military. That hearing is scheduled for tomorrow at 1:30 Pacific time. The judge there knows that this is an emergency, and I suspect he will rule very quickly. But as you know, that will only be the beginning of this. This is something where we can expect this will go up and likely will eventually be decided by the U.S. Supreme Court. They're finished with their normal calendar, but their emergency docket remains very active. And so it could be a matter of just really weeks.
So I would close before I turn over to my colleagues and say this. I'm frustrated by the fact that the president is doing this without legal or constitutional authority. I'm frustrated by the fact that we are in the minority in Congress and can't have a fulsome debate of the whole committee and the consideration of legislation. But I'm heartened by the fact that this president has lost over 90% of the cases which he has brought to court to try to enforce his executive orders. He's issued a record number, over 150 executive orders in just a few months, and I'm sure he'll continue to do that to flood the zone, as they call it. But the courts have responded, as I've said, with over 90% of the cases finding against the president, which is encouraging. At the same time, there are those who argue, oh, those are political judges. You hear that from the White House. The fact of the matter is, over 70% of the judges appointed by Republican presidents have been ruling against the president as well. 80% from Democratic presidents. So it's close. So I would just say, don't give up. Keep your wits about you as this terrible situation unfolds. My feeling for the victims like Ms. Cristobal is personal and emotional. But we've got to keep a steady hand on the controls here and move toward a constitutional resolution. I believe that the senator from New Jersey is the next one, President.
Mr. Chairman, thank you very much. I'm grateful for the witnesses that are here. I'm grateful for others as well. We are in a crisis moment for the United States of America, for our constitution, and for our shared values. And we see this by a president who's pursuing a course that violates our laws, that violates our morals and our ideals, that is an attack on our Constitution, that is bringing chaos, corruption, and cruelty to the fore in the United States. I'm grateful to hear the comments by my colleagues and the responses that have been given by our witnesses today, but let's just be clear. The deployment of the National Guard and military troops was an unlawful exercise of authority. It was an action that is provocative and creating more of a crisis than it is solving, when even the police leader of Los Angeles is saying that this makes it harder for them to do their job, is a testimony to Donald Trump's end not being strength in our streets, security in our streets. It is a testimony to what he's really trying to do, is create more and more of a provocation and more of a cause for him to violate our laws. Just last month, we know that Los Angeles is not an isolated incident, because all around the country we're seeing outrageous flaunting of the law. Just last month, the DOJ took the unprecedented step of arresting the mayor of my city, Newark, New Jersey, outside an immigration detention center. The DOJ charged a United States Congresswoman, LaMonica McIver, who was exercising her congressional oversight authority to inspect that detention facility. And as people rushed out, agents rushed out to wrongfully arrest a mayor, catching her up in the process, and now they're bringing charges against her. Trump brought us to the precipice of a constitutional crisis when he deported more than 250 people to an El Salvadorian prison under the Alien Enemies Act without allowing them to appear before the judge, 50 of whom came into this country legally. And when a unanimous Supreme Court ordered him to bring back the individuals who by the government's own admissions had been mistakenly deported home to avail himself of the constitutional mandated process he was entitled to, the president refused to comply. The price that we are paying right now is immeasurable, but I see it all around New Jersey. Our streets are less safe. Our economy is being severely hit. We have victims of crimes who are afraid to come forward to bear witness against the person who victimized them. We are seeing law enforcement resources invaluable to stopping crime being pulled away from other agencies and directed to the invasion of schools and courts, as we've just heard, to tearing apart the fabric of our community, not to get criminals, not to get violent gang members, but to separate families and to, in so many instances, truly undermine the very people who give strength to our communities and our neighborhoods. And so I am doing what my other colleagues are doing. We need to sound the alarm. This is not isolated pockets of activity. This is a larger, comprehensive effort to go through that is trying to undermine our Constitution, our values, and slip us further and further towards authoritarian rule. And so I want to ask again, and I think it's really important, Ms. McCord, the legal work that you're involved in. And I just want to just to clarify this point I made about the declaring of national emergencies that are being done. First of all, the circumstances in Los Angeles and early Saturday, there was no clear following of the rule, and I think it's Title 10, Section 12406. It is a clear, if you read that statute, violation to be sending in the National Guard around the governor's office, correct?
Excuse me, the statute requires that orders to federalize the National Guard must be issued through the governor. And at least based on the governor's allegations in the lawsuit, he was bypassed.
And then I want to be respectful to my colleagues because my time is pretty much out. But for Americans to think that a president who violates the laws and the rights of marginalized people, that does not implicate them and their constitutional rights, could you do me a favor when it comes to his using trumped up reasons to declare national emergencies? If the president continues in this way, there are over 150 powers that become available to him, including things like suspending the Clean Air Act or taking possessions of certain lands for war purposes or shutting down domestic transportation. There's a scenario, do you think, where the president could declare an emergency and postpone or delay an election even? Is that correct?
That's untested, but the emergency powers are capacious. I don't think Congress ever intended them to be that capacious. But this is, I think, an important point, as you indicate, because this is not all about non-citizens, right? This is about the impact of presidential action on all of us, including citizens, and our rights, our constitutional rights, including the right to vote.
And that's what I want to conclude on. Again, the courage, again, of Ms. Arias-Cristobal, it's extraordinary. You are an extraordinary American, showing extraordinary courage. But I think the point I want to drive home here is if we do not show public outrage, he will continue to push to get away with things. That's why a lot of people that he has arrested and detained have been released actually because of the public outrage. This is a man that is saying it is unpatriotic, un-American to protest. When a president is violating the Constitution and the law of the land, to be silent is what is un-American. Patriotic is to show, being patriotic in a time like this is to show dissent, peaceful, lawful, but dissent is necessary if we were going to stop this president from his continued encroachments into the constitutional violations that he's doing. So I appreciate that. Thank you for the indulgence in that of my colleagues.
Thanks, Senator Booker. Senator Blumenthal.
Thanks. Thank you, Mr. Chairman. Thank you for holding this hearing, and thanks to my colleagues from California for speaking with such moral clarity, and to Senator Booker for what he has said just now. And I think that we should all agree that silence is complicity. We have an obligation to speak out, stand up. Otherwise, all of our rights will be in jeopardy. And of course, none of us sympathize with any form of violence. We believe peaceful protest is a form of free expression. It's deeply rooted in our law as well as our tradition. And defending that right to peaceful protest, not violence, is woven into the fabric of our laws. What's happening here is that in many respects, the president's taking advantage of loopholes and